I'm going to be talking to Nigel Bankes, who is emeritus professor at the Faculty of Law at the University of Calgary, about something that has sparked a lot of interest on my social media feeds and probably yours too, and that's Bitcoin operators setting up in Alberta. So welcome to the interview, Nigel.
Thanks for the invitation.
Now, there was a case that went before the provincial regulator about Link Global, which is a Bitcoin operator, operating its own power generation facility. Can you give us just an overview of that?
Well, I'll try. So this was an unusual case because it was coming before the Alberta Utilities Commission, the relevant regulator, on a compliance issue, because the proponent, Link Global, had simply started operating these generating facilities and associated Bitcoin operations without any approvals from the AUC.
Right, and so they set up near an oil and gas well, if I were on a lease, if I understand correctly, and then some of the local landowners complained about noise.
Yeah, so there were actually two facilities, and so the complaint related to just one of the facilities, but the whole thing was rolled into a single proceeding. So yeah, the basic operation was that Link Global had gas generating facilities, gas turbines. They were buying gas from an operator, running that through the turbines, and then supplying electricity to actually initially somebody else's Bitcoin facilities. But at some point, Link Global buys those Bitcoin facilities, so it's simply one operation. And all of this is off grid, right? There's no grid connection. It's entirely a self-supply. And the advantage of that from Link Global's perspective, of course, is that it's not paying system costs. It's not paying distribution costs. It's not paying transmission costs.
So my understanding of your blog post is that the regulator tried to determine if there were two types of adverse effects, one upon local the community or that sort of thing, and the other on the environment. And so what did the regulator conclude?
Well, I think that the issue for the commission was really how is it that Link Global just started operating without any approvals? Because the normal rules would be, if you're building generation, you've got to get the AUC's approval under the Hydro and Electric Energy Act. And the usual rule as well is that if you're generating electricity in Alberta, you've got to transact it through the market, through the Alberta Power Pool. Now, there are exceptions in both cases, and the real question for the commission was, had Link Global triggered the appropriate exceptions? And so, if you want, we can talk about those two issues.
Yes, please. If you can just discuss them briefly, that'd be great.
Okay, so the first issue was, and the simplest issue actually, was the Electric Utilities Act. So as I say, normally, if you're generating electricity in Alberta, you must offer and you must exchange to the Alberta Power Pool. But there is a self-generation exception in the Utilities Act, which says the Act doesn't apply if you're self-generating and consuming on your own property. Now, the one snag for Link Global here, of course, is that they just had a lease. They weren't operating on their own property. But fortunately for them, the EUA has another provision which says, oh, and it's okay if you're operating on a lease. So that basically meant, from the AUC's perspective, the company was in compliance with the Electric Utilities Act. So we then move over to the Hydro and Electric Energy Act, which says, again, if you're engaged in self-supply on your own property, you don't need to make an application to the AUC for approval unless the AUC otherwise directs. And that was the issue here, because the AUC took the view we otherwise directed, and we otherwise directed in the form of a rule that we've got. This is Rule 7, and Rule 7 says that notwithstanding the exemption, you must submit an application to the AUC for approval unless you can establish that nobody is directly affected, that you're in compliance with the noise requirements of Rule 12, and there's no adverse effect on the environment. So the Commission, of course, goes through those,
Right. So the one I'm interested in is the adverse effect on the environment. And how does the regulator define what is the environment, and what conclusion did they come to?
I think what the Commission does is adopt a proxy. And the proxy is, if you're in compliance with all the general environmental rules of the province, we take it, we are prepared to assume that there is no adverse effect on the environment, absent some other evidence. And that's actually the rule the Commission applies where someone makes an application before them. Show us that you've met all of the general requirements of law. And in this case, there were two issues. One related to NOx emissions from the facilities, and the argument there was that if these generators were run at full capacity, they'd exceed the NOx emission limits. And the operator's response to that was, we'll actually operate them below capacity and therefore maintain compliance. And I think the Commission effectively accepted that. The other matter, though, was that there's a provision in the Environmental Protection and Enhancement Act, which says that if you are operating a generating facility with a capacity greater than 1 megawatt, and these were 3.5 or 5, you require an approval from us because that's a designated activity. And the operator in this case didn't have that application. Hadn't made that application for approval. So, I mean, one of the totally remarkable things about this, Markham, is this company just seems to be, picking up, finding a nice spot with a source of sweet gas, and to heck with the requirements. Doesn't even seem to have done the basic due diligence to figure out what the rules were.
So at the end of the day, is this Bitcoin operator allowed to continue generating electricity, Nigel, or something else?
The answer is no, it can't, and it can't until it files that application for approval with the Department of Environment. And where it's at on that, I honestly don't know, Markham.
So I guess is the takeaway from this, Nigel, I guess this could be just a one-off kind of an odd circumstance because the operators didn't even care about the rules. Or is there a bigger issue here about Bitcoin operators moving to Alberta to take advantage of cheap electricity and maybe doing the same thing as well? So there's any concern about that?
So I think the bigger takeaway is actually not specific to Bitcoin operators, but it's rather the exemption provisions of the Hydro and Electric Energy Act, because the idea that someone's got to satisfy themselves that there's no adverse impact, there's no adverse effect on the environment, it's fine as long as everyone's operating in good faith and acting with due diligence. But where you've got what I think is effectively a rogue operator, then there's no prior approval system. So I think my own view is that the AUC needs to look at that rule and put in place perhaps some form of expedited review and approval process for these sorts of facilities. So it's not just left to the operator to assess whether public interest considerations have been met. That's the bigger issue for me.
Great. Well, thank you very much for this, Nigel. Really appreciate your insights.
You're welcome. Thanks for the invite.